Thank you everyone for coming. And this is the part of the series of Business of Medicine of Neurology, things that we never learned in medical school, internship, residency, and fellowship. We really need to know. And tonight we're very lucky to have Roccy DeFrancesco. He's a known authority on asset protection. He's a certified asset protection planner, and he's got all sorts of other designations, and he's written books about this. So take it away.
Yeah, appreciate you having me on, and those for attending, either live or on recording. Yep. So I am what they call a recovering attorney. I'm licensed still to practice in Michigan. I'll try to keep my intro very short because we have a lot of information to cover. But for this audience, you might find it interesting that while I was practicing law, I blew my knee out, and the doctors that fixed me doubled my salary to come run their medical practice. So I was actually working at a law practice that specialized in suing physicians, ironically. And then I left there to go run an orthopedic clinic for 3 years. So while I was there, I treated my doctors like I would in law. And I spent most of my time, not necessarily running the practice because it wasn't that difficult. I spent most of my time researching topics that could help my doctors. And the one that I really focused in on was asset protection. So I haven't dealt with a lot of doctors recently. I missed the audience, so it was great to be able to get out in front of doctors again. And so really appreciative of being here today. So we're going to go over asset protection planning today. And asset protection planning, the topic or the subject matter, depending on who you ask, you'll get different answers to what does that mean. If you ask an attorney or an asset protection guru, and there aren't that many left out there, they'll tell you that asset protection is protecting your assets from negligence lawsuits, which is true. But that's sort of narrow in my understanding and belief on asset protection. Now, I'm going to focus on negligence protection today, but there's a lot of other areas of asset protection that you need to know so that you can make sure that all of your assets are protected from all creditors. Again, I'm going to focus on negligence, which obviously is important to doctors who can get sued for negligence, just like attorneys can be sued for negligence. But if you ask an insurance agent, they're going to talk about the cash value life and annuities being protected in their state. Certified asset protection planners, actually that's a designation I created through one of my companies. We're going to help you try to protect your money from anyone or anything who can take it. So I always like to do education. If you would like to read my newest book on asset protection, 5-Pillar Asset Protection, be happy to give you a copy of it for free to read in an e-format. Where it talks about a lot of things that we're not going to cover today, but be happy to provide that as a free benefit for attending this particular webinar. I also wrote the book, The Doctor's Wealth Preservation Guide, wrote it way back in the day. My 9th edition is coming out soon. If you'd like a copy of my 8th edition as a free benefit for coming on this call, just email me at the email you see on the screen there. I'd be happy to email you a copy of it. But let's get into the 5 pillars. Again, I'm going to cover 4 of them in a cursory manner, then one of them very specifically. So the first one is the one that I'm going to cover specifically, which is lawsuit protection. So, everybody drives a car. If you're texting and driving, if you don't know this, texting and driving is 6 times more dangerous than drunk driving. And unfortunately, we all do it every single day. So you don't just have to be a doctor or a surgeon to worry about negligence lawsuits. Your spouse who drives a car, your child who drives a car. Texting and driving was a gift to asset protection planners because there's more lawsuits now with texting and driving than just about anything else. So don't just think about negligence from your patients. Be careful when you're texting and driving. Then obviously we have premises liability suits that we all know about in the old days where that was like the bread and butter lawsuit of most attorneys, a slip and fall. That's a negligence liability suit. And then obviously at the bottom there, we have doctors, lawyers, CPAs. I have highlighted financial planners, insurance agents, because that's my normal audience that I talk to. But we professionals can't hide behind an entity, so we want to protect against that. Who is your number one guaranteed creditor every single year? It's the IRS. So when we're talking about helping clients with asset protection, we want to talk about your number one creditor, which is tax planning. So if we can reduce capital gains taxes or estate taxes, we can do a form of asset protection. So that is pillar number 2 in my book, and we want to talk about that. Again, that's not what my focus is today, but we can use tax deferred, we can use IRAs, we can use charitable planning, we can use cash value life. There's a lot of things that we can do out there, Delaware statutory trust. So that would be pillar number 2. Now, this is an interesting one that usually raises an eyebrow of most people. The stock market. Why am I talking about the stock market as a creditor? I mean, we've been on a 13-year bull run in the market, but the stock market is a creditor. I think that every doctor on this call will agree with me that it's important to protect your assets from negligence lawsuits, including your patients. But you're much more likely to lose money in the stock market in any given year than you are to be sued for negligence. But we don't think of protecting our money from downturns in the market. So what we do as asset protection planners is we do a review of everything we can get our hands on, including your investment portfolios and your IRAs, your 401ks, your non-qualified plans, to make sure that those investments are hedged for risk in the stock market. So that's pillar number 3. Long-term care, long-term care is going to be one of our largest expenses in retirement. So one of the pillars that we protect on or talk about protection is how do we protect against this expense? And actually, these numbers on the screen, I need to update. They're actually a little bit more than that. And if you project them out, yeah, I don't know how young you are on this call. I'm getting older every year, but in 10 years, 15 years, 20 years, what's going to be the cost for a private pay nursing home? It could be 200,000. It could be 220,000 a year. So protecting against this huge future expense and doing it in a way that is economical today is pillar number 4. Estate planning doesn't necessarily fit easily into an asset protection sales pitch, if you will, but estate planning is very, very important. As an attorney, it's really important to me to make sure that advisor or that clients have their estate plan set up, your wills, your trust, your durables, your durable powers being your legal and your medical powers. And then advanced estate planning for those who have more money using slats and dynasty trusts and freeze partnerships and things that I'm not going to go into today. But the reason we want to have our estate plan set up properly is pretty simple. We want to avoid probate costs, which is what many of you hear. We want to avoid estate taxes for the affluent. But one of the things, again, that I'm not going to cover in any meaningful way today is when you pass wealth to your heirs, it's really important not to give outright distributions to your heirs, which we see all the time, because it's really easy for an estate planning attorney to set up these documents and say, well, when you die, we're going to hold these assets and we're going to give them to your kids 25% at certain ages. And then after a very short period of time, your heirs actually own all of your assets. Now, if they're married, 50% of the marriages in this country end up in divorce. When you give a significant amount of money to your child, and they're married, they're going to put it in the marital bank account. And then it becomes a co-mingled asset. And then if their spouse divorces them 2 or 3 years later, guess what? They're going to go after half of your inheritance. So I like to write estate planning documents that hold on to those assets in trusts with liberal language to give it to the heir. But that's just something that we want to talk about to make sure that your estate plan is set up in a way that you like it. So we're talking about an asset protection puzzle. This is actually a new image. ChatGPT is great. They can create really cool looking images. If you think about your asset protection puzzle, what parts do you have done? Is your estate plan done? Long-term care, tax planning, life insurance, annuities, stock market protection. So think of your puzzle and how many puzzle pieces do you have put together? So now we're going to get into core asset protection planning from negligence lawsuits typically. So when we're going to put together an asset protection plan, we want to use a multiple entity approach if possible. Sometimes we're going to use debt shields, which is a fancy term for keeping debt on an asset to make it an ugly asset so a creditor doesn't want it. We're going to use segregation techniques, depending on whether they're liquid investments or real estate or valuable equipment with the business. We don't want to lump them all in the same asset protection tool because they inherently could have their own liability and they could put the other assets in that entity at risk. So multiple entity approach and segregating assets. So when we're doing asset protection planning, we're going to look to the law, and the law is going to give us some asset protection tools. Depending on the state you live in, your homestead could be protected or not. It really depends on the state. Let cash value life and annuities in your state could be protected or not. These are things we have to look up. Your wages up to a certain amount in all states are protected. That's probably not an issue for the crowd today. But mostly when we're doing asset protection planning, we want to take action. Because most of us, including myself, even though I'm a 13-time author and all the crazy things that I do, I'm really good at doing nothing. I'm good at sitting down and watching football and doing nothing. That doesn't help you get your asset protection plan in place. So it's my job to motivate people to take action. And when we take action, we're going to use structures and entities. So it could be a family limited partnership or an LLC. We might use offshore. We could use irrevocable trust. And again, we could use debt shield. So we want to take action. So who needs asset protection planning? It sounds like a really simple question, but I want to go over it. So anybody who's a high net worth individual. So I don't generally do a lot of estate planning and asset protection planning for people who don't have money because they don't have a need for asset protection. So we want to allow those who can't hide behind a corporate entity like a physician, an attorney, a CPA, financial planner, insurance agents, architects. We can't hide behind our corporate entity versus those who start a business. I'm originally from Southwest Michigan, and in Southwest Michigan, we have a lot of tool and die owners. They're making the parts for the cars that are made in Detroit. And if I was making a car part and I was selling that out of a corporate entity and it was set up correctly, I personally wouldn't have any asset protection issues with defective products from my entity. But again, we as physicians, doctors, et cetera, we can't hide behind it. So it's very important for professionals to do asset protection planning. There are reasons, again, that I've already talked about that non-professionals, so those on this call, you may have a son, you may have a daughter, you may have a brother, you may have a sister, whomever, that you want to motivate to do asset protection planning. Just because they're not physicians doesn't mean they don't need an asset protection plan. If they have a residence, they have an asset protection issue. If they have teenage children, they have an asset protection issue. If they have a boat, an automobile, a wave runner. Again, I said I'm from Michigan. In Michigan, we have two different things. We have a lot of boating in the summer, and we have snowmobiling in the winter. When you ride your snowmobile, all you do is you go from bar to bar to bar when you're doing snowmobile up north. That's all you do. And there are a lot of injuries in the boating community on wave runners and people drinking on their boats, et cetera. So these are all assets that cause liability. And obviously, if you have vacation rentals, those also cause liability. And you see underlined there the cell phone, which I've already talked about the cell phone. So you have a little one there, bullet point number 2 at the bottom. If you have teenage children that have parties at your house, that's a problem. One of the things you do need to watch out for, I'm sure there aren't any drinkers on this webinar or this call. My dad was an attorney for over 30 years. We used to have Christmas parties at our house every winter, every Christmas when I was a child. Those that came to the Christmas party were a bunch of lawyers and judges. And what do lawyers and judges do when they go to a Christmas party? They drink, and many of them drink very heavily. And we had a party when I was a kid where one of the lawyers that came to my parents' party had overserved themselves, or my parents allowed them to get overserved, is what a lawyer would say, drove home and wrapped themselves around a tree. Now, there was no injury with that, but if that attorney that left really got injured, they would have sued my parents, just like my parents were a bar that overserved somebody. So lots of reasons to motivate yourself to get an asset protection plan in place. So what assets should be protected? This is really easy. Anything of value: homes, rental properties, IRAs, stocks, mutual funds. You can read the list here. But again, basically anything of value. And don't forget the one at the bottom there, a future inheritance. So the person that is giving the money away is the one that can do the asset protection plan. Your parents who are going to give you money, they could do an asset protection plan to protect that money. You giving the money to your kids, you're the one who's going to create the asset protection plan instead of maybe giving those assets outright to the child. So again, I talked a little bit about the homestead exemption. If you're lucky enough to live in Texas, Florida, Oklahoma, and certainly Texas and Florida, you don't have any state income tax. That's great. I actually live in Fort Myers, Florida, half the year. They have unlimited homestead exemptions. So if you're there and you cause somebody injury, your home is going to be protected. But there are certain states that have very little protection. If you're in California, I think the protection's like $180,000 or $190,000 is your total protection. I mean, you can't even buy a double wide in California for $190,000. So depending on your state, you need to know your homestead exemption. Life insurance as an asset protection tool, I don't think you should buy it just because it's protected, but in a lot of states, you have 100% asset protection for cash value life. And I've written books on cash value life as to why they can work as a nice retirement tool. But again, Texas and Florida have full protection. States like South Carolina have very little protection. So you want to know what state you're in. If you happen to live in a state that cash value life isn't protected and you happen to have a lot of money in cash value life, we can show you how to protect that. And so this is a little bit on estate taxes, although they're up now. If the Democrats ever get back in power, which I'm sure they will someday, they will try to get rid of the estate tax exemption. So if you end up with an estate tax problem, keep in mind your death benefit, if not owned by an irrevocable trust, is part of your estate. So if you have a $5 million estate or an $8 million estate and a $10 million policy, you got to add it all up unless your life insurance is owned by an irrevocable trust. Annuities, again, I'm trying to get through this stuff pretty quickly. Just like life insurance, certain states, complete protection. You could have $1 million, you could have $2 million in annuities, totally protected from creditors. However, you could be in a state where there's almost no protection from creditors. And it's really important to know your laws. Also, I didn't say it anywhere in this presentation, but if you would like a download with all 50 state laws, which talk about homestead exemption, life insurance, IRAs, annuities, I have that. It's a simple email. I'd be happy to email you a PDF of all the state laws. Retirement plans? Well, I imagine most of the doctors on this call have a fairly sizable tax deferred account, whether it be a defined benefit, a 401k or whatnot, profit sharing plan. You should know that those are 100% protected from creditors. So your ERISA governed plan, your 401k, et cetera, those are 100% protected from creditors. Here's the list: your 401ks, defined benefit, et cetera. So if you have money in these plans, congratulations, they are protected from creditors. Now we can talk about the benefits of overfunding a tax deferred plan and why they can sometimes be more tax hostile than tax beneficial, but that's a presentation for a different day. If you have a SEP, and there's a lot of smaller employers that use SEPs because they're cheap and easy to use, they're not technically protected by federal law. So if you have a SEP, they're not technically protected by federal law. But this is one where I've never seen them attacked because usually they will be given ERISA protection anyways. This is one of those, if it walks like a duck and acts like a duck and looks like a duck, it's a duck. And so even though a SEP is not technically protected by the ERISA law, generally courts are going to protect that. The big one that you have to worry about is IRAs. So you're going to retire and you're going to roll your money from your 401k, profit sharing plan, whatever, to an IRA. IRAs are protected in a little over 26 of the states out there. That means there's still some 20 states, et cetera, that do not protect IRAs from creditors. And so while you may be retired, you're still texting and driving, you can still get the lawsuit. And maybe you've got $1 million or $2 million in an IRA. If you're in a state where it's not protected, that's important to know so that you can take steps to protect it. And there are a few things you can do to protect those IRAs that we can talk about in a separate discussion. But you should know that there is a case out there that if you happen to file for bankruptcy, your IRA is going to be protected. Now, I would imagine that if you run into a lawsuit, almost nobody on this call is actually going to file bankruptcy because of the lawsuit, which means if you have money in an IRA, that IRA money really is going to be at risk. This next schematic is really the simple way to protect an IRA if you're paranoid about it. There's many, many reasons that a retired person or a person that has money in an IRA should have a family limited partnership, a family LLC. Once you create a newly formed entity, in that entity, you can create a profit sharing plan, a retirement plan, and you can roll your IRA into the newly created profit sharing plan and then instantly protect it. It sounds like it may be a lot of work, but if you have $1.5 million asset in a state where IRAs are not protected, it's not that difficult to get this accomplished. So this is the way that you would typically protect it. All right, what I'm going to go over in the next 2 or 3 slides is 90% of domestic asset protection planning. And if you know what I'm going to talk about in the next 2 slides, you will know more than 95 to 98% of the CPAs out there, 98 to 99% of the financial planners out there, and 90% or even 95% of the attorneys out there. Just like you were not taught this subject matter in med school, attorneys are not taught asset protection planning in law school. So if you know this, you will know more than most of the attorneys. So we're going to talk about inside creditors and we're going to talk about outside creditors. An inside creditor, if you get sued by what we would call an inside creditor, the only thing that creditor can get is what is inside the entity. And this was my example earlier where I said with a tool and die owner that puts out a defective widget into the stream of commerce. If that widget is put out through a C corporation that was set up correctly, or an LLC that was set up correctly, or an S corp that was set up correctly, and if it had $2 million in cash in the entity and $5 million worth of valuable equipment in the entity, those assets are at risk to the lawsuit because they are inside the entity that is being sued. It is an asset of the entity. But at the bottom there, you see that it could be the sole shareholder of the entity. If the sole shareholder of that entity had $1 million in a personal brokerage account, that is not at risk because the exclusive remedy to this inside creditor is what's ever in the corporate entity. So if you own your own medical practice and you have valuable equipment or you have real estate and it's owned by the medical practice, whoever helped you set that up did you a disservice. The valuable equipment should be outside of the practice. The real estate should be outside of the practice because if the practice ever gets sued, you don't want what's owned in the practice to be at risk. So this starts to get to the bifurcation of assets and where we put them. Now, the outside creditor is the doctor with the patient. or the texting and driving. So I'm a doctor. I did something wrong. I had a bad outcome, or I was texting and driving, and I ran somebody over on the side of the road. Now the person that sues me is what we call an outside creditor. That outside creditor can go after all of my assets. It can go after my C corporation interest, my S corporation interest. That $1 million personal brokerage account that I have in my own name is the very first thing the creditor is going to go after. They could also go after your vacation condo. So this is why we do asset protection planning of your assets. We don't want that outside creditor getting access to your brokerage account, getting access to your condo. So I know this may sound simple, but I'm telling you, they do not teach this sort of stuff in law school. Now, the bread and butter tool that we're going to use are domestic multi-member LLCs or FLPs, and we'll make this presentation available to everybody. And I'm going to skip through some of these wordy slides. I've left them in there because I'm just going to get to the schematic that that talks about it. So it really gets into the remedy that the creditor can be given by the judge. So here's our example. We have the creditor on the right. That's your patient that's suing you. You have your assets, and let's say your assets are owned by a multi-member LLC set up in the correct state. So we use Wyoming, we use Alaska, you could use Nevada, you can use Delaware, you can use Michigan. There's a whole bunch of states that you can use their LLC statutes, but you want to use the LLC statute or the state that has the magic language, which says the sole remedy of the creditor is a charging order. And you see the charging order there in that red arrow. If you don't have that in your state statute, you do not want to set up the entity in that state. And by the way, there's nothing wrong with somebody living in Texas or Florida or Tennessee and using an Alaska LLC to own their brokerage account or their rental property. There's no problems with that. So here's our example. Doctor gets sued. Doctor, let's say instead of having the brokerage account in their own name, capitalized in a multi-member LLC set up in the correct state that is a non-taxable transfer, capitalizing the LLC. And then the judgment comes down from the court. It's a $3 million verdict. It's a $5 million verdict. What can the creditor get when it comes to the assets that are in this LLC? The judge, look, the creditor cannot become a partner or an owner in the LLC. They can't touch the assets. They can't vote your interest, and they can't force a distribution. What does that leave them with? It leaves them with this charging order. So the judge writes this order, puts their name on it, says, here you go, creditor. Here's your charging order. And the creditor says, what is this and what can I do with it? I can't force distributions. How do I get my hands on the money in the LLC? And the judge says, I'm sorry. If the owner of that LLC doesn't take money out of it, you don't ever get it. So if that's the case, what would we do? Let's say normally that the LLC has an investment account, and it's usually going to be a growth account. The doctor's 57, 55, it's growth assets, right? What I would do with that, if there was a charging order, I would take all of my stocks, I would sell them, and I would buy all dividend income stock. Now, when we have dividend income stock in an LLC, and normally would be treated as a pass-through for tax purposes, there's no double tax. Normally, at the end of the year, whether you took the money out or not, as the owner of the LLC, you get a tax bill for that income, that dividend income. However, if there's a charging order on that LLC, guess who gets the K-1 for the income? It's the creditor, because they have the right to any distribution from that LLC. There's this Rev ruling that you can see 77-137, which has never been challenged. It says that the creditor is going to get the K-1 for your income, even though they got zero income and the income actually stayed in the LLC. So in all the years I've been doing this, almost 30 years, I have never seen a charging order on a properly set up LLC. Now, if we had one, what I would do is I would send the creditor the K-1 at Christmas, and I would also send them a Christmas card or a thank you card. Hey, thank you, creditor. Thank you for having this charging order. I just created $50,000, $75,000, $100,000 worth of income in my LLC, and I don't have to take it on my tax return. You do. This is why I think I've never seen one. So this, again, is 90% of domestic asset protection planning. We're going to use properly set up multi-member LLCs set up in the correct state. Now, if you have a vacation condo, we do not put your vacation condo in your LLC that has a brokerage account. Why? Because the vacation condo is a liability asset. There could be liability with the real estate. There's no liability with the brokerage account. Nobody's going to slip and fall over your brokerage account. So while people don't like to hear this, if you had a rental property, a vacation home, and a brokerage account, proper asset protection planning would be 3 separate LLCs. And they're not that expensive to set up and to run. But again, what I've just gone through is 90% of domestic asset protection planning. Oh, there we go. What assets should be in these entities? Real estate, brokerage accounts. Now, you could put a plane, a boat, a snowmobile, a wave runner in an entity. You don't do it necessarily for the value of the asset. You put it in there because the asset is a liability asset. Now, that doesn't help if you're the one driving the snowmobile, but if you let somebody else drive your snowmobile and it's in an LLC, you personally are not going to get sued for it because they can only sue the LLC and then any other valuable asset. So this is what an asset protection plan may look like. I'm not really going to go over it, but we have walls. We're trying to build walls in front of creditors and your assets. Again, we could use Alaska, Arizona, Nevada, whatever. We could go international, and we're trying to get that charging order. So if you don't have if you don't have a plan that looks something like this, if you have multiple assets like a brokerage account and some real estate, maybe it's time that you were proactive to take a look at that. And I know I blew through that really quickly. This was being recorded. If you want to email me, I'll be happy to get you my books where you can read through them. But my goal on a presentation like this, frankly, isn't to make you an expert in asset protection, because I can't do that in a 30-minute webinar. My goal is to take you where you may be on the left side of this thermometer, which is, I don't know how, I don't know what I'm doing. And it's my job to move you up that thermometer, either by education or working with you directly. I believe I will, and I did. So that's our goal as an asset protection planner. And so the summary is, most people do not have an asset protection plan. I can attest to that because I've been doing this for almost 30 years. And I can count on one hand the number of people I've reviewed and said, oh my gosh, you have an awesome asset protection plan. I almost never say that. So we want to have a plan that protects you from negligence lawsuits, from taxes, from large risks in the stock market, from long-term care, from probate, other legal issues. You can create plans that are simple. You can create them that are complicated. You can create them that are inexpensive or expensive. But please, at the bottom there, fight the inertia of doing nothing that we're all really good at when we get our free time. We're all really good at doing nothing. Please take the time to review your current plan and take proactive steps to put one in place. So that was really quick, hopefully not too quick, and it was a good teaser on the basics of protecting your assets from negligence lawsuits.
Thank you, Rocky. I have a question.
Yeah.
In the state of Florida, are IRAs protected?
I believe they are. I can confirm that after the call by just emailing you our 50-state asset protection chart, but I believe IRAs are protected in Florida. Florida is a very proactive state to do asset protection. IRAs, real estate, your homestead, et cetera. So I think the answer is yes.
Okay, thank you. Oh, is there a limit on your homestead? I used to, my recollection was years ago when there was either 1 acre in the city or 5 acres outside the city, or is that true anymore or not?
Not necessarily, and it's going to be state specific. So if the government is giving you homestead of your property, generally it is your homestead. Now, if they're making you bifurcate it into different parcels, that's something to think about. And I've not seen any states that limited it, but that's not to say there aren't some out there. I don't work in all 50 states personally. The more interesting question or item that I would want to throw out there that I didn't say earlier was, everybody remembers Enron. Remember when Enron went bankrupt and the executives of Enron all had $10, $15 million houses in Texas, and they got to keep their houses. So they did change the law in a lot of the states that have full exemptions, that you have to live in it for at least 2 years in order to take advantage of the full exemption. So what you can't do is run somebody over with a car and then go buy a $10 million house and then protect it, because that's not going to work. That actually it did before Enron, but the laws got changed. So if it's a new house, a new purchase, you can have a couple-year waiting limit or waiting period before you get full exemption of it.
Great, thank you. Anybody else have questions? You said the family LLC.
You can do family limited partnership. You can do family limited liability company. You can do LLC. They're all a little bit interchangeable.
What's the difference between the family and the regular LLC?
So not from a practical standpoint, none. Um, the reason we're going to use them separately is really the business purpose. So the business purpose of an LLC, because you have a medical device that you created or you invented, you're going to put that into an LLC, right? A multi-member LLC. If I want to form a family structure, because I want to put family assets in a structure, generally I'm going to call it a family limited liability company or a family limited partnership. But practically speaking, there's no difference. It's just, what is the business purpose? You're not going to use a family limited partnership typically to start a new business for yourself. Not that you couldn't, but it's sort of a name without distinction.
Okay, thank you.
Yep.
I have a question. What asset level do you recommend
Yeah.
before it's worth investing in asset protection planning?
That's a great question. So it depends. It depends on the paranoia of the client and how much they want to spend. So let's talk about the brokerage account. So those of you who have brokerage accounts with financial planners, forget the stock market risk mitigation issue. You know, if your brokerage account is around 500 grand or more, some would say 250 or more, is it worth a $1,500 LLC setup fee and $250 a year to keep it in place? Is that worth protecting a $250,000 asset or a $500,000 asset? That's the question. Because literally, different firms charge different things for these structures. We're fairly inexpensive with what we do. It's usually $1,500 for the first LLC and $750 if you need more than one. And then usually you got your filing fee. You know, if you use Alaska, your filing fee may be 175 or $200 a year. So you tell me, is it 200,000? Is it 250,000? Is it a $300,000 asset? When do I get to the point where I want to spend $1,500 and a couple $100 a year for the protection? So that's really a personal preference, with no right or wrong answer per se.
No, these are brokerage accounts, not in the pension plans.
These are brokerage accounts in your own name. So again, your 401k, your profit sharing plan, your defined benefit are protected by ERISA. You roll that to an IRA. Whether your state protects the IRA is another issue. I'm talking about, you took money home, you pay tax on it, you got a Schwab account with Edward Jones or whomever, your personal brokerage account.
I thought that wasn't protected if it's in your name. I thought it has to be like in your joint tenants or something like that. But if you're saying my brokerage account in my name is protected, is asset protected?
No, I must have done a terrible job in my presentation. Your brokerage account in your own name is not protected.
Right.
And that's why we would put it in a multi-member
Oh, it's not
LLC.
protected. Gotcha. Okay.
Yeah. Yeah, and don't use joint tenancy as a way to try to protect assets. It's a terrible way to do it. Or joint life. You know, I own an asset with rights of survivor with somebody. It's a lousy way to do estate planning too. There's so many ways to do things that are easy and simple that are bad, but CPAs recommend them and clients do them because they're simple and cheap. You know, just try to avoid doing the easy way all the time.
Yeah, I know. I learned the hard way.
Yeah. Okay. Well, then you know what I'm talking about. I get it. Yeah.
Yeah.
What's a safe amount to keep in cash? Let's say, I mean, you've got stuff protected in other assets that are under LLC protection. I understand it usually takes a couple of years to get through a lawsuit. Then they have to. Can you sort of 4 years worth in cash, spend it all, or what's kind of safe?
Yeah, no, that's another really good question. So I have the majority of my assets protected by entities, so I did a really good job. How much can I leave sitting in cash and not worry about it, right? I'd say it could be 100,000, could be 150,000, because you're absolutely right. It's going to take 2+ years to get your way through the litigation, and you can spend assets that you have on regular stuff and not have it be a quote unquote fraudulent transfer, which I didn't cover today. So you want to worry about these fraudulent transfers, but 2 years later, today I got 100 grand in my bank account. I could spend that on food. I can spend it on travel. You can do, guess what else you can do? You can massively overfund your 401, your profit sharing plan, your defined benefit, which would require you to spend your savings at home on living expenses. None of that runs afoul of the rules. So you could keep quite a bit of money in cash and not worry about a lawsuit because you'll be able to spend that before the lawsuit comes through. But good question. Although I argue against cash long-term because it's a lousy way to grow your wealth, but
Well,
you could do
it could be stocks, it could be bonds. I mean, I'm just saying something
yeah.
that
I
is
mean, that just gets
not
back into
protected 529 or sorry,
well, as you say, that gets back
401k.
into when does my brokerage account arise to the level of wanting the LLC?
Sure.
Whether it's in a brokerage account or whether it's cash, it's the same issue.
Yeah.
You could have 100,000 in a brokerage account, have the lawsuit, liquidate the brokerage account, and spend it on your living expenses, no problem. But once you start getting $300,000, $400,000, $500,000 in a brokerage account, it becomes much more difficult to spend that money down before before the lawsuit comes through, before it finishes.
I don't think you've met some of our wives.
No.
Pardon?
I don't think you've met some of our wives when you
Well,
say it's difficult
you
to
know-
run for
you know-
$300,000.
Yeah, that's fine. That's cool. I'm just, a lot of these are personal preference answers. So my job is to make sure you understand the structures, the pros and cons of them, what works, doesn't work. One thing while we're still on the phone here, don't buy into anybody trying to sell you on how to hide assets from creditors. It's a total scam. If you're using a land trust or you've been told about a land trust, it's a scam. Land trusts, yes, they have anonymity by ownership, but they are revocable trusts. Just like your estate plan with your revocable living trust, just because it's a trust, there's zero asset protection with a land trust. There's zero asset protection planning with your estate planning trust. So don't think that because you have a trust somehow it's protected. It's not.
Can you go on mute, whoever's making that noise, please?
Brad.
What about what do you think about whole life or variable policies for
Yeah.
investments and asset protection?
Well, I've written a book called Retiring Without Risk that covers the use of cash value life as an asset, as a retirement tool. I also have a software company that runs the numbers on the viability of cash value life as a retirement tool. My stance is very simple. I'm not a fan of whole life, even though it can be an asset protection tool, because it's very expensive and the returns are very muted. The returns are very low. I'm not a big fan of variable life because you virtually have no asset protection when it comes to stock market downturns. So if you haven't looked at indexed universal life, that is my preferred cash value life tool. I have software that illustrates it. Again, I cover it in my book. I don't have a dog in the hunt either way. You should also know that I own an insurance wholesale company where we work with 600 independent advisors. So I could make money from whole life, from index universal life, et cetera, universal life. I think it's a great asset class, cash value life in general, as one asset class. Again, I'm not a fan of whole life, whether it's Northwestern or Mass Mutual or Guardian, New York Life, and I'm not a fan of VUL. I'm a fan of indexed universal life. Now, if you go to the web and you research these topics, you'll find that you'll find haters on everything. Indexed universal life is terrible. Whole life is terrible. Variable universal life is terrible. As an attorney, I try very hard to look at things objectively and break down the math and the probabilities of it. And then I build software to run the numbers myself. And I just believe in the probabilities that an indexed universal life will significantly outperform whole life. Are you going to be harmed by buying whole life? Not necessarily, but especially if you're a higher income, higher net worth client, you don't need the quote unquote protection and the pathetic guarantees in the whole life policy. You just don't need it. And if you have one and you're out of your surrender period, you should definitely look at 1035 exchanging it to a better product. And one of the things about whole life is they never show cash flow when the insurance agent gives you an illustration. They never show cash flow. You're not buying it as an accumulation asset. You're buying it because when you want cash flow from your cash value life policy, you can take the money out tax free via policy loans. They never show that cash flow because it looks terrible in a whole life policy. They just talk about accumulation. So look, my most popular book, if you want to get a copy for free, it's really easy. My most popular book is Bad Advisors, how to identify them, how to avoid them. I am the dirty little secrets guy in the industry. I know where all the bones are buried. So if you just go to badadvisors with an S.com, badadvisors.com, you can download it for free. It will be a huge eye opener, and some of you will make your skin crawl based on the advice that you've already been given that I'm calling bad in the book. But it's a great read. It's a great way to protect yourself from bad advice from advisors, badadvisors.com. Or you can just email me as you see it here on the screen, and I'd be happy to email you a PDF of the book. I also have it on audio, but that's definitely my most popular book. I'd be happy to stay on if anybody wants to ask any other questions, legal or otherwise, but
Anybody
Can you
else?
speak to Delaware entities and what your thought is on having a certain amount of money available for liability exposure?
well, I'm not sure I fully understand the question. So Delaware is a state that is used quite often in the LLC game. We don't generally use Delaware unless there's a really specific reason to use Delaware because it's really expensive. Now, in the big scheme of things, it's not expensive, but compared to other states, Delaware is a very expensive state to incorporate or use an LLC. The reasons that we use Delaware is like if you had a medical device that you were going to have an invention and you created a medical device and you're going to bring in other investors, we would definitely use Delaware because there's shareholder protection laws in Delaware that are better than any other state in the country. So in that regard, we would use Delaware. If you are just using it for practical purposes for asset protection, we would never use Delaware because it's just too expensive. The comment about keeping extra money in there, I'm not sure I understand that. One of the other things I didn't talk about.
Let me readdress Delaware.
Yeah.
As far as I know, Delaware does not require disclosure of ownership.
Yeah, it's irrelevant. That's the biggest scam in the world. You might as well use a land trust. Look, I come from a very practical world where my dad was an attorney and I practiced law for a few years. Here's what happens in a lawsuit and why anybody telling you to use Delaware because it has anonymity is a total idiot or a scammer. So here's what happens in a lawsuit. You get sued and you lose. When you lose, you get brought back into court. And when you get back into court, the judge tells you to bring a lot of info. And then it's called a debtor's exam. And the other side that you owe the money to, they put you on the stand, they make you raise your right hand and they say, do you agree to tell the truth? And you agree to tell the truth. And then they give you a piece of paper. And the piece of paper says, could you please list all of your assets for me? Oh yeah, and there's a special part at the bottom, all those assets that are hidden. The ones that are hidden, I need those too. And the ones that you think are hidden because they have anonymity, I need those too. There is no way to hide assets in a lawsuit unless you're willing to lie to the court. So anybody pitching Delaware trusts or Delaware LLCs or Delaware entities, or again, land trusts is the one that I mainly see out there. It's a total scam. Not that there's anything wrong with using a Delaware entity, but don't do it because it has anonymity. That's a total scam.
Rocky, if one were to buy property in another country like Canada, let's say, and you get sued domestically in the US, is there protection cross-border, or will they go after that asset typically? They'll go after it, but
no, they're going to go after every asset you
yeah.
own. The question would be, how do they get their hands on it? I don't know off the top of my head the Canadian laws on what, because what you'll have to do is you'll have to take your judgment, the creditor who sued you, they're going to have to take the judgment and they're going to have to go to Canada to satisfy it, which is why a lot of times when we do our LLCs, if you don't want to use a domestic LLC, you want to like add another layer of protection. A lot of times we'll use Nevis as a an island out there called Nevis. We'll use a Nevis LLC instead of an Alaskan LLC. And then to satisfy that judgment, the creditor has to go to Nevis to satisfy it. So that doesn't work well with real estate. Again, stay away from anything international. If the property is domestic in the U.S., because the judge can say, I don't really care. The property's in the U.S., I'm going to seize it. But if you email me that, I'd be happy to get you an answer as to what the protection features are of having an asset owned in Canada or an asset in Canada. My off the cuff answer is if I could still own it by an Alaska LLC, it would be protected, properly set up. But I don't want to state that as a fact. But if you want to email me, I'd be happy to look that answer up for you and get it to you.
Can you talk about vacation homes again?
Yeah, sure.
And
so
yeah,
It's just an asset. You know, A, do you have any debt on it? So having a vacation home in Colorado that's worth $1 million with $900,000 in debt, you don't need to do anything because there's not enough equity that anybody's going to care. You take that same property, whether it's $500,000 or whatever it is, with no debt or very little debt, to me, that's an asset worth protecting. And so the way you protect it is very simple. We're just going to set up a multi-member LLC in Wyoming, Arizona, Nevada, whatever, and then we're going to protect it. You know, having it owned jointly with your spouse doesn't help. Having it owned by your revocable living trust doesn't help. You need to put it in an entity to protect it.
Thank you.
In a different entity than your brokerage account. We don't want to use the same one.
Great. Anybody else? Well, looks like that's it. Rocky, thank you so much. I appreciate it. I mean, you really are good at this, and you know your stuff, and you got lots of questions, and I'm sure there's other questions that we haven't asked, and maybe after people look at the video, they'll ask more questions. So again, I thank you very much. And just the next one will be it's always the last Wednesday of every month at 6:30, and the next one is going to be Mark Eichberg. He runs our pension plan with Ingham, and he's going to be talking about different pension plans and the good, the bad, and the ugly. And please make sure that you make that one too. That'll be good. We haven't planned the ones in July, August, and September. So if anybody has any suggestions, anything that you'd like to hear about, please let me know, and we'll make it happen. And thank you everyone for coming.
I thank you. Appreciate it.
Thank you very much. Excellent.
Good night, everyone.
Thank you.
Bye-bye.
Good night.